This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
This is Bloomberg Law's Intellectual Property Review. I'm Josh Block. The proposed settlement in the Google book search litigation was rejected by the U.S. District Court in March. That case highlights the legal issues created by mixing copyright law with technology, and specifically the legal implications of mass digitization. The U.S. Copyright Office took up the topic in October, releasing a report that urges that the time is now for intense public discussion. Ananda Shankar Mazumdar, legal editor at BNA's Patent, Trademark, and Copyright Journal, joins me now. Ananda, the rejection of the Google Books settlement proposal brought attention to the issues created by mass digitization. Will you explain what mass digitization is in general terms?
Mass digitization is the taking of large numbers of text form works and converting them into electronic form. Before 2005, digitization was being undertaken on an individual basis, limited projects initiated by individual publishing houses or libraries or archivists. Library of Congress was doing some digitization. But at that point, Google changed the game by announcing that it had entered into an agreement with some of the world's most prestigious libraries to digitize their entire collections. None of the previous forays into book digitization had been so comprehensive or ambitious.
That was Harvard and University of Michigan. And who were the partners in this?
Harvard was involved, Michigan was involved, Oxford University in England was involved. There were a handful. There have been a lot more that have signed on since then. So we're talking about some very big libraries, some of the world's largest libraries.
From a policy standpoint, there are reasons why we as a society would want to allow mass digitization, why it's in the public interest to allow libraries to have digital copies of their collections. What are the benefits?
Some of the benefits are the general searchability and availability of a massive amount of what some people are calling the corpus of human knowledge, in the form of books anyway. A lot of books that are out of print or difficult to access or not very well known will become available not only to ordinary Internet users who just happen to have an Internet connection, but to scholars, scientists, researchers, students. And these are works, a lot of works that might have been languished or inaccessible or unknown. There's also a potential benefit to the authors of such works, especially those that aren't backed by massive publicity or distribution networks. They might be more able to find an audience for their works, a relevant audience, that didn't know about them. There's a lawyer here in Washington called Jonathan Band who has represented libraries in this Google Books dispute. And he mentioned that he had been frustrated as an author because he had written a book on a particular legal subject, and there were all kinds of articles that could have used his book as a reference, but instead, because, for example, law students' journal articles are available online, people were citing to law students' articles rather than to his book. And his point of view is, my book is better, but people didn't have access to it. So Google Book Search will allow people to find it and use it and maybe buy a copy. And there are also some cons here. For those works that are still protected under copyright law, this process arguably violates a basic tenet of the copyright system, that you have to ask permission before you make use of a work. Part of the concept of copyright law is not only that authors get compensated for their works, but also that they have control over them. They get to say who can reproduce it, under what conditions, in what form, who gets to distribute it, at what price. In essence, they have the right to say no. And maybe an author doesn't want Google to have his work. Maybe he wants to find another way to distribute it, maybe through an exclusive arrangement, maybe in a way he thinks that will be more beneficial to him, maybe by a competitor of Google, if such an entity were to come into existence. Mass digitization, in addition to making out-of-print works accessible, also has the effect of bulldozing over this kind of right of authors that still hold valid copyrights to exercise the control that the law gives.
That picks up the sense of Google making money off of this. But we can go to libraries and get books anyway, and to some degree this is just a transformation of the brick-and-mortar library into a digital one.
It is in a sense, but remember, a library has a copy of a work because the author gave somebody permission to make that copy and sell it to the library. So what's the difference here is that Google is not seeking that permission. The library only has copies that the author has given permission to be made and sold. That's not what's happening with Google. They're going ahead and digitizing works and taking the position that they don't have to ask for permission to do that.
Mass digitization will have an impact on what are called orphan works. What is an orphan work? How does a work become an orphan? And what are the copyright implications of scanning an orphan work?
Orphan works is actually a larger issue separate from mass digitization, but it does have a role to play here. Putting it simply, an orphan work is a work that somebody wants to use, make a copy of, sell a copy of, do something with. But the user is unable to get in touch with the person who holds the rights in order to ask permission. Now, it's going to be relatively unusual for a work published by a major publishing house to become orphan, because you should be able to get in touch with their permissions department and get a yes or no from them. But there are a lot of works that maybe were self-published or published by defunct companies, or works that really never became well-known, or the author died and the ownership transfers are not well documented. For the most part, these are going to be works that were probably not very successful commercially in the long run. But the issue is that for whatever reason, either you can't figure out who owns the rights, or you can't figure out how to get in touch in order to ask for permission.
The U.S. has implemented the principles of the Berne Convention, and how does that complicate the orphan works issue?
Well, one of the tenets of the Berne system is the elimination of the requirement that a copyright owner has no rights until he or she registers his interest. Before the U.S. adopted Berne principles, you had no rights under U.S. law until you registered your work with the Copyright Office. Now, under the Copyright Act of 1976, your rights manifest as soon as you have fixed your original creative work in a perceivable medium. What that means is that there is more opportunity here for a copyright owner to go missing, because we aren't requiring that every protected work be registered with the name and contact information of the relevant copyright holder. So, the Berne Convention can, in a way, aggravate the orphan works problem.
Legislators and government officials have expressed that it's in the public interest to use and benefit from works, even if they've been orphaned or if they're out of print. Yet one of the reasons that the Google Books settlement was rejected was because if the court had accepted the settlement, the court would have essentially been taking on the role of Congress and making law. Why is it best for the legislature and not the court to determine what should happen with orphan works?
As a basic matter, Article 1, Section 8 of the Constitution gives to Congress the right to create the terms under which copyright protection is granted to authors. As the law now stands, the owners of orphan works have exactly the same rights as the owners of non-orphan works. With certain exemptions or exceptions, you have to get the copyright owner's permission before you can use a work, and this applies equally whether you are able to actually get in touch with the copyright owner or not. But the real question here is whether it's Congress setting the rules for orphan works, and not whether the alternative is the courts doing it, but rather whether it's Google doing it in collaboration with the copyright owners across the table in this litigation. And they're going to set pretty sweeping policy standards for how the rights surrounding orphan works are administered. And a lot of people interested in copyright law don't want to cede this kind of broad policy-making authority to a single large commercial interest in the form of Google. After all, what interest do they have in ensuring that the orphan work authors get the best deal? The orphan work authors are not at the table. And that's why the Copyright Office and others believe that there should be a legislative solution. There's sort of a conceptual argument here. Congress is supposed to weigh various interests, including public interest, including interests of authors who aren't there in court, and set a broad policy standard. And at least some people are arguing that this should not be left in the hands of litigants, and judges, for the most part, get arguments from the people who are in front of them. In this case, yes, it's true, the court did reject the argument, or reject the settlement, but they did so in the face of a lot of people coming to them and saying, we don't want this to apply to us. But obviously, none of those people were orphan works authors, because the definition of orphan works is that you don't have the author in front of you.
There have been attempts to pass orphan works legislation, but they've failed thus far. Do you have a sense of what's gone wrong and where that is?
The issue of orphan works is broader than just what's going on here in mass digitization, and this is a very good example that you're asking about. At least one reason legislation has failed is because of the objections of for example, photographers and other visual artists. And this is sort of based in the nature of photography as a technology, as well as its nature as a profession and as a hobby, maybe. So take a look at book authors or screenwriters or playwrights or composers. In a lifetime, how many works can somebody like that create? How many screenwriters or novelists have hundreds of credits? Song composers might be able to produce more work than a book writer, but not a lot of composers have thousands of works to their name. Steve Allen, the talk show host who died about 10 years ago, he claimed to have composed something like 14,000 songs, but you don't find very many songwriters who even come close to producing that many works. On the other hand, look at photography, and especially with digital technology that allows a photographer to produce huge numbers of works in very short amounts of time. Not only that, but the way photographers work, a lot of them work on their own, even if they're professionals. They might not have the resources and time to register all their works. There's a lot of disputes in the Copyright Office about how photographs can be registered. A lot of photographers want to do them in bulk because they have so many, they can't do them one at a time. The photographers, if they're working on their own, they might not be easy to get hold of, and most importantly, they might not have the ability to police the entire world for unauthorized uses of their works. And you look at the nature of the works here. If you've got a book or a song, it might be pretty easy to figure out where it came from or who the creator is. If somebody mentions a book to you or you hear a song when you're working out at the gym, it's usually not that hard to, say, go on the internet and figure out what it is. And if you're, somebody who wants to make a copyright use of that work, to figure out who owns the rights. But things are different with photographs and other visual images. It's not necessarily very easy to identify them or tell them apart from similar images taken by other photographers. And even if the original publication includes credits, like a cut line, or if it's electronic, something in metadata giving the copyright owners information, if you're talking about digitized images, the way photographs are often used on the internet, all that stuff is stripped away, and you can't get access to the information. So photographers are worried that orphan works legislation is going to put a huge burden on them, more than they already face, and create a situation in which it's pretty much open season on digital images. And they don't like the idea of changing the presumption that you don't get to use a work until after you've gotten permission for it.
Is there a sense that there could be some sort of carve-out or some sort of exception for a book author as opposed to that scenario that you put forward?
Well, they came pretty close to a deal the last time that this came up in Congress, and there was a sense that they would be able to satisfy some of the photographers' concerns, but legislatively they kind of ran out of time, and that's happening now again. In fact, and things that have happened since have made photographers even more concerned about what might be going on with their future if orphan works legislation comes back. And it might be more difficult to satisfy them now than it was a couple of years ago.
Is there some sort of licensing model that Congress could look at, or I assume there are multiple licensing models? Is there a likely one, some sort of mandatory licensing or something that might end up being a legislative solution?
Kind of. I don't know if licensing is the right word here, because you can't really have a license unless you've got somebody with whom you can negotiate a license with. And that's the problem with orphan works. There's no one on the other side of the table to negotiate with. That's why there are people who want Congress to step in and say, okay, we know you've tried to get hold of this author or photographer or whatever, and you've made reasonably diligent efforts to get in touch with them and get permission, so we're going to give you some kind of provisional ability to go ahead and use the work. And if the actual copyright holder shows up later, you won't be completely on the hook for infringement as you otherwise might be. Whatever licensing or other situation that might crop up if in the face of, if there's a successful bill passed, it might be something like the situations we have with statutory licenses or compulsory licenses like now exist for radio stations to play sound recordings. In the Google case, in the proposed settlement, the parties had agreed to set up a private organization that would collect royalties for uses of orphan works and distribute them in if any author of such work were to come, appear sometime in the future. And they had also obviously set up something for the authors that were there at the table, royalty distribution system. And there are several examples of royalty collectives in operation now. And given that other similar disagreements are worked out, it doesn't take too much imagination to, set up a similar system for orphan works if some kind of protection is given to users.
No court has taken up whether the fair use doctrine would be a defense to the copyright infringement that would take place in a mass digitization effort. Do you have a sense of how that might be determined? Is there one of the factors of the fair use doctrine that might likely be determining? How would courts weigh that?
This really is the big question, Josh. Google is arguing that it doesn't have to ask for permission to go ahead with mass scanning because it's fair use. And the authors and publishers say, no, it's not fair use. And fair use is really one of the trickiest areas of copyright law. There are some kinds of uses that we all know are fair use, like using quotations from a book or a clip from a movie in a review in a newspaper or, a TV show or radio show. But when you get into new areas of technology, it's often very difficult to understand in advance whether something is going to be judged to be fair use. The copyright holders are going to focus on probably the third fair use factor, which is the amount and substantiality of the work. And they're going to argue that you're making a copy of the entire work here without our permission, and a wholesale copying has never been seen as a fair use. They're also going to take a look at the purpose and character of the use, which is the first fair use factor, and emphasize the fact that Google is a commercial entity and is going to be making income through advertising and other means. On the other side, Google is going to look at the purpose and character of the use and say, we've got a transformative use here, which is a term relevant to this area of the law. We're taking the text of your book, but we're not using it to give our end users the experience of reading the book. We're using it to allow them to do a full text online searching so they can locate books they might be interested in. And, I don't like to make predictions, Josh, but I think that this transformative use question is the key to this case. It's a very important issue. Google is also going to look at the fourth fair use factor, the effect on the value of the work, and they're going to argue not only are we not interfering with the current market of your works, we're actually creating an opportunity to increase the potential market by allowing so many more people to find out that your work exists, and if they're doing a search for this, maybe they're interested in the subject, and maybe they'll even buy a copy. So you have arguments on both sides, and I'm not sure exactly how it will come out, if it ever does.
And do you see any likelihood that a court will ever apply the fair use factors, that it'll ever make that far in a case?
As we sit here now, Josh, the Google and the plaintiffs seem to be on the course for trial, but we'll see what happens. It's been several years now, and they've tried very hard to come to a settlement. And I think that's a very important signal that neither side really wants to risk going to a court and losing if they don't absolutely have to. And so I expect that they'll continue to prefer not to have a court put the argument to the test. And another thing you've got to take into account here is that Google is the 800-pound gorilla here. There have already been some indications that the authors and publishers were desperate to have their last settlement deal approved because they were running out of resources to fight Google. And Google, on the other hand, has a ton of money, and they have the ability to wait them out. And in fact, there was some speculation that a few months ago that maybe Google would just win by default if the authors and publishers simply did not come up with the resources to continue fighting them. And Google has never stopped doing what it wants to do, and they would just keep on going.
There are additional concerns with the Google book search settlement, in particular the plan the Authors Guild and Google had for out-of-print books. Can you explain that?
Well, the proposed settlement assumed that all books, whether in print, out of print, orphan, public domain, whatever, would be included in its scanning and searching for Google Books Online. And there was a provision that said if an author didn't want his book scanned and made searchable on the Internet, that the author could come back and the term is opt out by a certain date. In other words, by opting out, a copyright owner could say, you cannot scan my work and you cannot put it in the database. But this is one of the most contentious parts of the two settlement proposals. And the objectors, there was a group of authors who didn't like the deal that went to the court and said, don't approve this deal. And they didn't like this at all. And the thing is that a lot of critics described this aspect of the settlement as, the words they used is turning copyright on its head. So the way copyright law is set up is that an author gets rights in a work, and the assumption is that if you want to use that work, you have to ask permission. What the opt-out aspect of the settlement essentially did was set as the default the assumption that Google could use any work, and if an author didn't like it, he would have to come forward and revoke permission. And to a lot of people in the copyright community, this reversal here doesn't sit well, in the same way that the shifting of the burdens didn't sit well with photographers when we were talking about the orphan works legislation.
Do you have a sense of whether Google is lobbying Congress at all to try and get some legislation that would take care of this?
I don't have a very good sense of what's going on behind the scenes in legislation in mass digitization and orphan works. Google has turned out recently a huge lobbying effort to oppose some bills currently before Congress in the area of rogue websites. But I don't get the sense that they really have to do a whole lot of lobbying in the area we're talking about. At no point has Google shown signs of slowing down its digitization efforts, and it's moving full steam ahead, letting people who object to it come after them. And Google's argument in the first place is that it's fair use and not infringing. And that essentially means that it's saying that the law as it stands supports them. And so why should they have to seek a legislative change? And so far, no court has ruled saying that they're wrong about that. They haven't ruled saying that they're right either, but they're the ones sort of in the pilot's seat here. And if any sort of settlement were to go through before trial, no court will ever say otherwise. And so Google's got a huge war chest, and they can really just sort of keep doing what they're doing. And if some point somebody says they have to stop, then it's possible maybe then that they might start lobbying on the issue, but they might feel that they're really already so far ahead of the game that people will still have to cut a deal with them, or they won't benefit from the pros of their project.
As I mentioned in the introduction, the U.S. Copyright Office has released their analysis and discussion paper on mass digitization. On the Law Librarian blog, a post about the Copyright Office analysis stated, and this is a quote, "If I may read anything into this document, it would be that mass digitization is generally a good thing, that other countries value their historical and cultural institutions by undertaking their own substantial projects, and that Congress not only has the power to do something that can balance the interests of libraries, museums, and other archives with those of rights holders, but that it really, really ought to exercise that power." Ananda, you've read the Copyright Office report. Is the Law Librarian blog post going too far and reading too much into it, or is that about right?
I don't think it's going too far. I think there is pretty broad agreement, both in the area of mass digitization and in orphan works, that Congress does have the authority, and that there are good reasons for Congress to exercise that authority. The question is really whether they will do it, and that's where the sticking point comes into account. And if they do it, who's going to be on the short end of the stick and who's going to be on the long end of the stick? It really becomes a very common legislative political issue. But I think that it is correct to say that there is general agreement that Congress can do something about it and should do something about it, but we don't know if they will.
In regard to the U.S. Copyright Office report, how influential can that be? How influential will it be in getting Congress to move on this?
The Copyright Office has actually been pursuing this for something like 10 years now, and they've had a very consistent position that something needs to be done, And then Google came up and they said, see, we're right, something really needs to be done now. But I'm not sure, the Congress does respect the Copyright Office's opinion on these things, but the Copyright Office is not a political player, really. They're technocrats, they're bureaucrats, whatever. They know what they're talking about, and people understand that. But that isn't necessarily enough to get legislation through. There's got to be something more on the political side. There's got to be something pushing Congress to say, hey, this really needs to go through. Somebody out there wants it. Having the Copyright Office on your side saying, yeah, this should be done is one thing, But it's another thing to actually have a constituency to say, you need to sit down and pass this legislation. And I'm not sure that that really does it.
That's Ananda Shankar Mazumdar. You can find out more about the legal implications of mass digitization and the Google Book Search litigation at both BNA.com and BloombergLaw.com. You can find new intellectual property law podcasts each week on Bloomberg Law's YouTube channel, at bloomberg.com/podcasts, and on iTunes. Thank you for listening.
Copyright 2011 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.